California. So I'm the executive director of a joint powers agency that oversees flood risk reduction on the Pajaro River. And the Pajaro River, just for context, like Darren mentioned, we're on the central coast of California. The Pajaro River feeds into the Monterey Bay, and in its lower reaches divides the counties of Santa Cruz and Monterey. And so because of that political divide that the river creates, we formed a joint powers agency to oversee maintenance on the river, which includes maintenance of levees that were built by the Army Corps in the 1940s that were in the process of rebuilding, but because they were built by the Army Corps, we of course have an O&M manual with performance standards and other requirements that we are required to adhere to in our maintenance activities. And so we engage in a lot of different maintenance activities on the Pajaro River, on the levees themselves, and within the river channel to maintain flood conveyance capacity and to make sure that the levees are in good working order and in good condition. And as Darren has showed all of us, we have found similar issues in the river from homeless encampments, ranging from large amounts of debris, either in the channel or adjacent to the channel, that can become easily transported during floods and can rack on other woody debris or at bridge abutments and cause blockages. We have water quality concerns associated with the encampments. Some of them have built quite large structures. You can see here in the bottom right that there's a structure built up off of the ground, which is good that they at least had enough sense to build up off of the ground away from some of the flood flows. But what they understandably don't appreciate is how easily flood flows can overwhelm even elevated structures that they've tended to build in the trees. And then we've also had fires. And as I'm sure many of you have heard about or have even directly experienced, wildfires are a very real and ever-present issue in the Western United States, and that's very true for the Central Coast on Pajaro as well. And so one of our member agencies last year had plans to engage in homeless encampment cleanup and debris cleanup on the Pajaro River. This is the stretch of the Pajaro River near the urbanized centers along the river. So on the north side of the river is the city of Watsonville, and on the south side is a much smaller town called the town of Pajaro. Most of the homeless encampments exist in that vicinity for obvious reasons, because it's in close proximity to resources that those unsheltered individuals tend to utilize. But it also means that they've created encampments and dugouts into the levee in some of the most critical spots adjacent to those highly urbanized areas. And so it presents a real threat. So our member agency, the Monterey County Water Resource Agency, had plans to address homeless encampments in the shaded regions on this map, the blue, the pink, and the green areas. They had identified bulk collection sites where they were gonna, the sequencing of what they were gonna do with cleanup and storage of temporary materials. And what I wanna present to you is just a quick play-by-play to give context. So on November 10th of last year, the Sheriff's Office assisted the Water Resource Agency to post and issue a 7-day notice to vacate the premises and the notice of cleanup throughout the encampment. So there was info provided on storing personal belongings, a list of resources. So there was some care groups that were involved with this on the front end. What you'll learn quickly is the legal case that was generated out of this. The plaintiff in the case, which I'll describe shortly, claimed that there were 200 unsheltered persons, while the Water Resource Agency was claiming that there were about 25 to 40 unsheltered individuals. But those were that population was the subject of this clearing activity. So on the 17th, 7 days later, the clearing began, and later that day, the court received the plaintiff's complaint and application for a temporary restraining order and preliminary injunction against the Water Resource Agency and the Sheriff's Office. And of course, Water Resource Agency opposed the TRO and the preliminary injunction. The court granted the plaintiff's temporary restraining order application on the 18th, the next day. And a few days later, on November 22nd, the court held a preliminary injunction hearing. And the plaintiff is the Pajaro-Watsonville Homeless Union. So Scott mentioned a similar homeless union up in Sacramento. These homeless unions, at least in California, exist all over the place. They brought an ex parte application for a temporary restraining order and preliminary injunction against the county of Monterey, the Water Resource Agency, the sheriff's office, and the sheriff himself, actually. And the jurisdiction in this case was given to a magistrate judge. And I'm playing wannabe Scott here, so I'm an engineer, but there's going to be a lot of kind of legal outcomes from here that I'm going to describe. And so if I misspeak, Scott can correct me. But I've found this sequence of events really interesting and kind of instructive into how things are proceeding for us and potentially for others, at least in California. So the case was named the Pajaro-Watsonville Homeless Union versus Monterey County. So in the legal proceedings, what I had read from the judge is that in order to obtain a preliminary injunction, the moving party, meaning the plaintiff, must establish a couple things. One, that that they're likely to succeed on the merits and the qualifications that they're bringing to bear. That they were likely to suffer irreparable harm in the absence of some type of preliminary relief, that there's a balance of equities that tip in their favor, and that an injunction is in the public interest. So in examining all these things, what I want to do is just quickly go through what was found. So on the part of the requirement on the merits, so the questions asked was there a state-created danger? In other words, did the Water Resource Agency and the sheriff create a dangerous situation by the activities that they were performing? And did the county leave these unsheltered individuals in a situation that was more dangerous than the one in which they found them? Did removal put these people in increased COVID harm because they might be then dispersed throughout the community, which could increase the potential for infectious disease spread? And fourthly, were there no alternative shelter spaces available? And what the court had found was no, that these findings were inconclusive and not in support of the plaintiff's case. And what they established, and to echo a lot of what Scott had told us, is that the Martin versus Boise case didn't establish a constitutional right for these populations to occupy public property indefinitely at their own option. And to reiterate again what Scott said, that Martin only holds that so long as there is a greater number of homeless individuals in a jurisdiction than the number of available beds and shelters, the jurisdiction cannot prosecute homeless individuals for involuntarily sitting, lying, and sleeping in public. So the absence of alternative housing alone wasn't here sufficient to show a likelihood of success for the plaintiff on the merits. And the difficulties the homeless individuals camping at the temporary campground may face are largely identical to those they would face while camping elsewhere in the county. Additionally, there was the court found that there wasn't any deliberate indifference, that the Water Resource Agency has in fact never permitted public access or use of the Pajaro River levee area. And this gets a little more pointed towards flood control agencies in particular, in that in our case, Water Resource Agency and the county determined that residing on the riverbanks and the levees present a serious and imminent health and safety risk for the persons encamped near the riverbed and the county's residents. So it's both a hazard to this population as well as a hazard to the community at large because of the activities, because of the restrictions that the population of unsheltered people are unintentionally imposing on the ability of maintenance activities to occur. So, and in our case, the Army Corps has noted deficiencies in conveyance capacity and encroachments. And so the Water Resource Agency has developed this plan to correct these deficiencies. And this is why they needed to vacate these unsheltered people and conduct the maintenance. And furthermore, the leveed area is not parkland. It has no facilities. So the presence of homeless has resulted in human and animal waste, trash, and other pollution, also has a significant effect on the environment besides just the flood risk itself. But the debris itself also, as I said before, impacts flooding potential. And the presence of homeless here is dangerous to themselves, being there, like I said, in the community at large because of flood risk. So was there in any irreparable harm? Again, the finding was no, because there was no merit found in the preceding slides that I told you about. Was there a balance of equities that tipped in favor of the plaintiff? The answer was no. The plaintiff's interest in their constitutional rights are outweighed by the defendant's interest in clearing the non-public space and maintaining the health and safety of the encampment residents and the public more generally. So what came out of this case were a couple of best management practices that we need to follow. And this was in part followed by the activities that led up to the encampment cleanup, including that the county and now our JPA must provide notice to vacate in advance. And so what they are instructed to do in this case is provide a notice to vacate on December 13th of last year and identify procedures to deal with personal property and that homeless are not able to take with them. And they were to store these personal items for 90 days. The restraining order would be lifted on 13th and the plaintiffs were supposed to vacate. And there was a meet and confer clause in addition on the availability of motel vouchers to establish that the number of homeless exceeded the 25 vouchers that were available. And the county was to provide transportation to the shelter and motel. But what's most important about this whole process is that there are some really capable individuals on both sides of the river in departments that are outside of flood control, so human and health services, that are now coming together to deal with two main problems. One is a more permanent solution to get housing for these individuals and to move them out of the river on a permanent basis so that they have resources they can rely on besides trying to rely on the quote unquote shelter that's provided by the river area itself. And then we're also trying to develop a more rigorous and well thought out protocol in the interim to evacuate people in advance of a forecast for a flood. That's the most imminent danger right now, ahead of having a more permanent solution for the well-being of these people, is to make sure that they're not put in harm's way unbeknownst to their own knowledge or absence of it on flood risk. And how do we deal with that in kind of an operational setting under the beginning of an emergency action? So I'll just leave it there and bring it back to Sunny. Thank you.
Thanks, Mark. So now we'll open it up for questions. We do have some questions in the Q&A section that I'll just talk through really quick, and then we can see if other people want to add in. One question was, when you are offering housing, a person experiencing homelessness housing, and they don't want the housing or want the help, what is the, how to handle that? And so I think, Helene, it looked like you wrote an answer. Would you mind just talking through that really quickly?
Sure, and Darren alluded to it as well. I mean, you have to ask how the help was being asked, who was asking it, what was being offered, and if there was a barrier related to that. So it does take time to have that sense of trust and relationship building. It's not going to necessarily happen that everyone is going to accept an offer of help by the first time they're being asked, especially if they received help before and it didn't work, and now they're feeling like this is going to put them in a worse situation. For example, is a shelter being offered? Did they go to that shelter before and they had a bad experience? Would they have to give up their pet that might be a companion animal for safety for them in order to get the assistance? Was it a law enforcement related perspective, or was it coming from a street outreach perspective? What time of day was the help offered? So I think you have to take that into big consideration, and a one-time no does not mean an all-time no, and that really connection is important and does ultimately work when that trust level and connection is made.
Great. Now the next question was, since encampment activity does happen and is allowed, why can't the flood control staff be allowed to rehab the watershed? If species and the vegetation is being compromised, and then at the end of the day, what is the liabilities of the government agency for not taking care of that area?
Yes, Sunny, I think I took the crack at an answer on this one. And, it was a little unclear to me what the question was asking, but it seemed to be asking, well, can rehab still occur? And the answer is absolutely, it can still occur, but there are two issues there. One is can it occur with the homeless encampment still in place? And the second is our public agency staff often comfortable in doing the work around the homeless encampment area? So whether it can occur with the encampment in place is somewhat the crux of what the presentation's on today. If the rehab work can occur without dislocating the encampment, then absolutely go and do it. There's no prohibition against it, and we don't run into the conflict that we're talking about. But the reality is often it does require the moving of the encampment. And then we're back to the examples that Mark and Darren have talked about, the legal constraints that I've identified, and some of the tools that Helene has talked about for trying to deal with the issue. I will note, and I don't think we've really talked about it, representing a number of public agencies, many employees are very uncomfortable doing this work. And whether it's an appropriate stigma or not, I'm not going to speak to that. My wife is a clinical social worker. She could probably better talk about that topic. What I can tell you is that there is a genuine fear of safety. Sometimes it's associated with all of the waste and the fact that there are sometimes needles and other biohazards in the area. Sometimes it is associated with a stigma that unhoused people have mental health issues and are dangerous. And so you do need to think about those issues. And maybe when I finish, Helene would offer a thought or two on that. On the final issue of liability, I can't really answer that question. It varies from state to state. And there are different obligations in different states as to how populations need to be protected and whether the actions we've talked about, if they went wrong, would result in some sort of liability. So I'm sorry I can't be more specific. If you want to ask a more specific question, I can try to answer it. Helene, can you offer any thoughts on this issue of the stigma of unhoused people as being dangerous and how we work with our employees to both educate them on what the real risks are, but also on how appropriately to deal with unhoused people?
Sure. Thanks for that. You know, and I think I was alluding to this a bit or commenting on this a bit about, it's about partnerships in terms of how best and who should be individuals who are engaging with people experiencing homelessness. And we shouldn't expect that engineers and people working on flood control districts and maintenance operators should also be social workers, right? And we shouldn't expect social workers to also know about the engineering of certain infrastructure. Having that connection and having those trainings available and having the ability for people who are trained to know how to interact well with people experiencing homelessness, know how to address people who may be exhibiting issues related to substance abuse or concerns related to behavioral wellness. That is an important approach that is very much needed. And so I think that instead of just saying this is something that's not going to work or it's too extreme or we're concerned about the safety issue, is how can we all work together in the roles that we're playing in and incorporating the people who are living in the encampments and working with them and finding solutions. We have seen time and again that policies that come up that are not bringing people experiencing homelessness to the table end up not working because there are things that we never would have thought of that those who have experienced it could bring that information towards to us. And so having that be part of the discussion, I think, engenders buy-in, engenders support, and better practices over time. So, you know, it's just like there are individuals who have substance abuse concerns or who have behavioral wellness concerns who are housed and they interact with people on a regular basis all the time. This is a situation where someone is living in an encampment. How do we bring in that expertise in to create a scenario where everyone's feeling safe and we can connect people to services?
Correct. There was one more question that just popped up. It says, has there been any legal precedent related to a municipality doing nothing in this regard and an injury or death occurring as a result?
Well, I know in the Sacramento area over the summer and over last winter, there were several documented cases of homeless folks passing away, and even some literally in front of City Hall. In front of City Hall has become an encampment area where the city does not move people. It's a sheltered area. And I'm unaware of any sort of legal precedent that would come out of it. Thinking about your question, I suppose one way to interpret it is, was there liability on the part of the public agency for not doing something? And I'm unaware of any legal actions that were brought in that context. You know, it's different again in different states, but in California, the real question is the public agency creating some sort of dangerous condition of property? Is, for example, the public agency purposely putting homeless folks in an area that is dangerous? And in that kind of circumstance, I think there could be liability. But we run a government system in the United States where there are very few affirmative obligations of the government to protect people in a particular way. And just think about this in the context of driving. Someone's driving down the road at 90 miles an hour and hits someone else, and someone is killed, and there was a police officer patrolling. It's hard to bring a lawsuit against the police saying you shall stop people who are driving 90 miles an hour. We just don't have the resources to do that. And so you apply that to this particular context, and you can see that liability would be a very unlikely thing.
Okay, great. Well, we are just 1 minute from our the end time real quick. And so there are some other questions that just popped up. We'll try to put together some thoughts or answers. Thank you both for posting those. Really quick about kind of next steps for NAFSMA and what we're doing around this issue is, you know, we're continuing to promote and promote collaboration and sharing success stories. Today was just one area we've been working on. And so how we're going to do that is we are creating a mentoring video that will share some stories from around the region of areas that are working on this challenging problem and experiencing some successes. And we expect that to come out this winter. We are working on putting together a website that brings all this together. So there'll be one area where you can find a lot of resources at. And then we'll continue to have these discussions on our member calls and at our annual meetings and work on this program together. And then finally, we are advocating the federal government for resources. We've had some really productive conversations with FEMA, the Corps, and EPA all together, where they're trying to find existing authorities already to help us with this issue, and then figure out what's next steps. They now have an awareness of how it's affecting everybody, and they're committed to helping too, which is a great next step for us. So I'll close out really quick just to advertise that our annual meeting will be next July in Seattle, and we'll continue to have these conversations there. So if you have any questions about the meeting or joining as a member of NAFSMA, we'd love to have additional agencies from the US to kind of expand our voice and hear all the other issues you've got going on. You can reach out to me or Susan or go to our website. And we really appreciate our panelists for being here and all of you guys for taking time out of your day to join us. And like I said earlier, we will send out slides and the recording to everybody that was registered. So look for that in your email probably tomorrow, and have a good day, everybody. So thank you.